Hello everyone, welcome to OpenLine. Interesting show tonight. We are talking with the Director of Litigation for a group that is not afraid to take Metro and the state to court. We're talking with Braden Boucek, Director of Litigation for the Beacon Center. Thank you for being with us.
My pleasure. It's Braden, by the way.
Braden, I'm sorry, I'm looking down here. Braden Boucek.
Couldn't be more common.
So, all right. Let's before we get into some specific sort of cases, which I think are all very interesting. There's one on sidewalks, home businesses, inclusionary zoning, all these things, past and present. 101 on the Beacon Center.
Sure.
Who are you? What is the Beacon Center?
So the Beacon Center, we are Tennessee's only free market think tank, for lack of a better word. So we work on free market policy issues. I was brought on in 2015 to start our litigation division, which does strategic litigation that has involvement in the various issues which we're already involved in on the policy side. By and large, most of my litigation can fall into a couple of silos: economic liberty, property rights, and free speech type issues.
Primarily conservative, would that be fair to say?
Conservative, libertarian. Our experience is when the media likes what we're doing, we're libertarian, and when they don't, we're conservative.
And where do you get your funding?
All of our funding is from the generosity of our donors.
So they're private donors?
Private donors, that's right.
Are they in-state, or where is it just all over? Where does it come from?
I think it's a variety, but I think it's mostly in-state. I don't have a ton to do with the funding, so I'm not in a position to say.
All right, so has there been a group that has taken Metro or the state to court as much as you all have here in the last few years? Before you, did anyone take them to court like this?
I think it had happened in some of the spaces that we work in, but it was very uncommon. We make a regular habit of it. We're in town, and we see ourselves as kind of watching the watchmen. One organization that I know has had involvement in suing Metro in the past is the Institute for Justice, which is a great organization. That's in fact the same organization that we paired up with on the home business case, and have a very close relationship working with them.
So you take Metro to court, you take the state to court. What about other cities in Tennessee? Are you taking Memphis or Chattanooga?
We would. We haven't yet. But we are here for any Tennessean.
And how many cases do you have going on now, let's say against Metro, and then the state? You know, what are the numbers?
Right now we've got 2 active cases against Metro. Yes, 2 active cases against Metro, and I believe 2 active cases against the state. And of course, we're already in the process of vetting new cases, and we've got a variety of ones that we see as promising cases on the horizon, including the sidewalk ordinance, which is what we're going to talk about a little bit here today.
So the sidewalk ordinance, you have not sued yet, right?
No.
But there's a letter here you've sent to the mayor. What is the issue here with the sidewalk ordinance?
Yeah, and before I get into that, I should say, you know, we're a little bit different than any other type of litigators because we're literally not in it for the money. The money means nothing to us. We really just want to make the city stop hurting somebody, and we don't really care how we get there. We don't need to win in the litigation to do that, and so if the city will just voluntarily stop doing that, that's a win for us, even if we never see a dime of any kind of funding as a result of it. So we did send the city a letter, and the reason why we send those letters is because we are just hoping that the city will see our arguments, consider them, and say, you're right, this is a major legal problem. Let's heed what these guys are telling us before we do get sued. And you know, it could always come from a private party who may well ask for a tremendous amount of damages, because when you violate someone's constitutional rights, that's always a possibility. Now, we don't do that. That's why we warn the cities, because we want to be good stewards of the taxpayer dollars.
You think there's an issue here where they could be sued for a lot of money with this sidewalk ordinance, is that right?
I think the sidewalk ordinance is very constitutionally suspect, yes, Ben.
And what is it? What is the sidewalk ordinance?
Yeah, so in a nutshell, what the sidewalk ordinance does is it requires homeowners to either construct or destroy and rebuild sidewalks in residential neighborhoods under certain conditions. And I could talk about the triggering conditions later, but as a general overview, that's more or less what it is. There's an option: if you don't want to pay, you can just give the city what's called an in lieu fee, which amounts to a bunch of cash that goes into their own private sidewalk fund.
So how does this realistically impact people? What does that mean for somebody?
So if you trigger the ordinance, what it means is you have to comply with very specific design specifications for not just the sidewalks, but also what are called the curbs and the gutters on the public roadways that are nearby. The curb, by the way, is the curb. Everybody knows what that is. And the gutter is that little area between the road and the curb that the water runs on before it goes into the water main. That's the area I always explain to people where I sprain my ankles when I'm jogging. But the city is requiring people to construct the sidewalks and the curb and gutters up to their rigorous design specifications. And it should be noted that you may be in a neighborhood where there are no sidewalks. Or you may be in a neighborhood that has perfectly functional sidewalks, and you would be required to destroy those sidewalks and rebuild new ones up to Metro's code. And so that's resulted in just a riot of absurdities. So for instance, in some parts of town that don't have sidewalks, you will see sidewalks to nowhere. You know, just a sidewalk in one yard that doesn't connect to a sidewalk, and there's not a sidewalk within miles. And you know, you don't have to look far on Nashville's Facebook. People are posting what are Nashville's now infamous zigzagging sidewalks, and these are areas that have sidewalks, and somebody triggered it, and so they had to rebuild a new sidewalk, and that sidewalk has to zigzag to connect to the old one, so it, you know, makes that kind of a pattern. And then in other areas you see things like perfectly good sidewalks that have nothing wrong with them, but if you've triggered it, you have to tear those up and rebuild them just because you've triggered the ordinance. And in some cases, one of the main problems with this is, you know, the sidewalks have to meet a specified offset from the street. Well, in many Nashville neighborhoods, there might be a gully there where the water flow goes. And so if you've got to actually move the sidewalk, you've now got to move the sidewalk where the gully is, and now you're responsible for all these major drainage issues. And now you're talking about a fairly substantial engineering project. You know, other instances are people where they're told that they've got to destroy an existing sidewalk, rebuild a new one, and that's going to mean the destruction of some really old trees in the yard.
So what we're talking about here is if you own, I guess, a piece of property, you want to build a house, and Metro is saying, well, we're not going to give you a permit to build the house unless you put in the gutters and the sidewalk and the other part, right? Is that what we're talking about?
That's exactly it, yeah.
So, all right, how many people does this impact? Are we talking about, does this impact big developers or everyday citizens? I mean, who does this impact?
Well, it's both, and I'm sure the intended target was just the quote-unquote big developers, but it really is 6 and 1/2 dozen of the other. I mean, businesses, that's been long said, do not pay taxes, they just collect them. And so even if you're just assessing these things to developers, it ultimately gets passed on to the homeowner. So one way or the other, it's going to the actual homeowner. And I will say that there's no distinction under the law between homeowners and builders. Anybody who triggers it because they want to do a new construction or even a renovation up to a certain specified value in multifamily units will trigger this, and it doesn't matter if you're the existing homeowner.
The sidewalk part has been there for a while, right?
No, even the sidewalk part is new.
So that's new. Are you objecting to the sidewalk and also the gutters and that, or just the gutters?
Yeah, both of them suffer from the same constitutional problem. The curb and gutter requirement suffers from an additional problem because there is no actual law that authorizes Metro to insist on that. I mean, one big difference between the sidewalks and the curbs and gutters is at least the sidewalk is on the homeowner's property. A curb and gutter isn't even on the homeowner's property, it's just on a nearby roadway.
So Metro passed a law about sidewalks?
Yes.
But you think the law is not constitutional?
I think the sidewalk law is not constitutional, yes, Ben.
And now I thought they'd been doing that for a little bit of time. Certainly.
It may span years, but it isn't a long-standing ordinance.
And so you would go, have you filed suit, or you're just saying you may file suit?
Well, we're hoping we don't have to file suit. That's why we sent the letter that we sent to the administration. I hope they read it and take those arguments seriously. And they go over this with their own lawyers, but I do think that they are looking at a very serious constitutional problem, and one that has gone up to the Supreme Court quite recently in a number of contexts, and the Supreme Court has been pretty resounding that you cannot tie the discretionary benefit like a building permit to someone surrendering their Fifth Amendment rights, which is what this is.
Now what if they said, okay, well, there's a law about the sidewalks, curb and gutters, I guess there's no law, we're going to continue to mandate the sidewalks, but not the curb and gutter?
Well, at that point in time, they would at least have a legal basis to require it, but it would still suffer from the same constitutional flaw. I mean, when the Constitution is in conflict with the law, the Constitution wins. All laws have to obey the Constitution. So Metro has no power to enact a law that flies in the face of either the Tennessee or United States Constitution, and this violates both.
So I think someone might say, well, when I go to get a permit, there's certain requirements that are placed upon me, and this is just another requirement. You know, so what's wrong with this additional requirement in order to get a permit?
Yeah, good question, and that is actually what the Supreme Court has recognized is a nexus test. And what that means is that you can attach permit conditions when the condition has some kind of a nexus to whatever it is that the permit or the denial of permit is trying to achieve. So in other words, the City of Nashville can only insist on you constructing a sidewalk or you constructing a curb and gutter if for some reason your building is something that would disrupt the sidewalk or curb and gutter. So to give you a contrary example, if you want to build an apartment unit and Metro says you've got to make sure the sewage line is at capacity or that there's sufficient water flow, or we would like you to install a traffic light, all of those things are perfectly reasonable because there's a nexus between what it is you're doing with that property and what it is that Metro is insisting you do. However, we are talking about situations here where you already have a single family home and there is no sidewalk. And the city is saying before you can make a new single family home here, you have to build a sidewalk. Well, there isn't anything about a new home in that area, or in other cases a renovation, that has any kind of a nexus to the actual existing sidewalk or the non-existence of a sidewalk. And all of that is to say nothing of the curb and gutter on the roadway, which builders would never have authority to disrupt on an existing roadway.
So it's a fascinating discussion. We're going to take a break. If you want to join the conversation, tell us what you think about all this. Give us a call. There's the number, 615-737-PLUS, 615-737-7587. Take a break. Be back right after this.